you. First, we're going to make a request for any bill introductions. Do we have any committee members with a request for bill introductions? I do have two. One is 25 RS 0958, rejecting the deference doctrine. And the other is 25 RS 0959, reducing the number of resident lawyers. Let me start that title again. Kansas Judicial Council lawyer selection. With that, those two bills will be introduced. Do we have any folks in the committee meeting room with requests for bill introductions? Sure. Senator Owens, come on up. Please introduce yourself and welcome to committee.
Thank you, Madam Chair, and thank you for your indulgence. I will just state from the onset, I miss my work in Judiciary already. I got to serve 6 years on this committee in the House and certainly love the work you're doing. With that in mind, Madam Chair, we're able to work with the revisers and actually get 4 bills finished up in time for the deadline to get introduced. So if I may, the first is 25 RS 666. Which ensures warrants issued in criminal cases can be accessed by compensated sureties. Would you like for me to list all 4, or would you like them individually?
You go ahead and list all 4. Thank you.
Okay. The second one is 25 RS 436, which creates the term of unsecured judicial release and disallows individuals charged with certain crimes from being released on unsecured judicial release. 25 RS 0544 criminalizes the use of lasers pointed at law enforcement aircraft. And finally, 25 RS 0963. This is a trailer bill regarding lending license requirements for compensated sureties.
Thank you, and the bills will be so introduced.
Thank you very much, Madam Chair.
Appreciate it. Sure, we have others in the committee meeting room. Sure, come on up. Please introduce yourself and welcome to committee. Let's stand by for just a moment till we have our reviser back. No hurry. Thank you. Go ahead.
Natalie is scrambling, I know. Madam Chair, members of the committee, good morning. I'm Steve Kearney. I'm here representing the Kansas County and District Attorneys Association. And believe it or not, even though it seems like it was a couple of months ago, just last week, Todd Thompson was here and did a little briefing for you all about our organization and talked to you about our legislative agenda and the bills that we were interested in having drafted. And those bills have been drafted, and I have RS numbers. I'm here today to request the actual introduction of those measures. So we'll start. The first one was if you recall, the search warrant bill, where we were changing. We discovered that over many years that the search warrant statute says any person, and changing that reference to law enforcement officer. That is 25 RS 0731. Would you like for me to go through all of them?
Sure, please go ahead.
Okay. The next one is, and I will tell you that we had one on habeas corpus on 1507 motions, which is now, we're going to partner up with the Attorney General's office on Senate Bill 60, I think you're hearing next week. So we're not requesting introduction of that, but we'll be working alongside them. The next one was basically a victim witness sort of protection process, adding a show cause notice for bringing witnesses in, so we didn't have to arrest victims or witnesses or have warrants issued for them. And this is hot off the press, just from the riser as we walked in, RS 0904. And then breach of privacy and child pornography. We talked about the surreptitious videoing of children, and we wanted to bring the sentencing into line between the two statutes so there wasn't a lesser penalty if in one statute than the other. And that is 25 RS 0740. And we had a hearsay exception change that we discussed in terms of medical providers and statements made to medical providers. And currently, our Kansas statute has the word physician in it. And as I think Todd explained, victims have a whole lot more contact, say, with EMTs or nurses or whoever. So it's 25 RS 0743, and it's changing that term to healthcare provider, as it's defined in 654915. And then, lastly, and Natalie, I may need you to help me with the RS number on obstruction or apprehension. So we had no, I'm sorry, that's 25 RS 0760, and that was folks harboring probation, folks that are in probation violation or otherwise from apprehension or prosecution, hiding them when they're being sought. So that's the list, Senator.
Thank you. Those bills will be introduced.
Thank you very much. Committee, thank you.
Appreciate it. They're going to keep us busy with all these bill introductions. Do we have any more requests for bill introduction? Make sure that if you have any, you get them in committee Monday. We will not be meeting Friday tomorrow, and the last opportunity to get those turned in is Monday, February 3rd. We're going to open the hearing on Senate Bill 61, requiring an electric public utility to pay a landowner's attorney fees when a party appeals the appraiser's award and the jury renders a verdict that is greater than the appraiser's award in an eminent domain action. With that, a bill brief from the reviser.
Thank you, Madam Chair. Senate Bill 61 relates to eminent domain law. The bill amends KSA 26509. That's the statute related to eminent domain procedure and the awarding of attorney fees. Current law provides there that when a plaintiff condemner appeals the award of appraisers and then the jury renders a verdict for the landowner in an amount greater than the appraisers, then the court may award the landowner attorney fees. This bill would create a special rule when the plaintiff condemner is an electric public utility and an appeal results in a verdict for the landowner in an amount greater than the appraiser's award, then the court would be required to award that landowner attorney fees. And I can take any questions.
Thank you. Committee questions? Seeing none, thank you very much. Committee, our first proponent in-person conferee is Wendy Grady, Assistant General Counsel, the Kansas Farm Bureau. Please introduce yourself and welcome to committee.
Is it on? Yes. Okay. Thank you, Chairwoman Warren and committee members, for allowing me to provide proponent testimony in favor of Senate Bill 61. My name's Wendy Grady. I'm Assistant General Counsel and Director of the Legal Foundation at Kansas Farm Bureau. I'm providing testimony on today on behalf of our KFB members. KFB is the state's largest general farm organization, and we represent over 30,000 farm and ranch families through our 105 county associations. Kansas Farm Bureau has long been a supporter of private property rights, but we also support the build out of electric transmission to keep pace with growing demand for energy. These two positions can sometimes be at odds, and our KFB Board of Directors created a working group a couple years ago to study energy issues and to see if our policy was in the right place. Out of that working group came almost 20 new policies that were adopted by our members, and a large presence in those policies was eminent domain. In fact, one of the policies was Gov 7, which reads, condemning authorities should be required to pay attorney's fees to parties whose property is being condemned regardless of the outcome of the process. So over the last year, I've had the opportunity to travel the state and provide education to landowners, farmers, and ranchers on electric transmission issues. And given the anticipated growth in electric transmission in Kansas, we think it's imperative to help provide some protections to landowners when an electric transmission company comes to acquire an easement on their property, but has eminent domain authority as a backup to being able to acquire that easement by negotiation. We think it's important for landowners to have legal representation through all phases of that, whether they are able to reach an agreement with the utility company or whether they have to go through eminent domain. But the cost of an attorney is often a deterrent, or sometimes just makes it impossible for them to get that legal representation to help them in those situations. So for those reasons, we support Senate Bill 61, and I'm available for questions if you have any.
Thank you. We're going to go ahead and hear from proponent conferees and then open it up for questions.
Okay,
So please stand by. Thank you. Next, we're going to hear from Aaron Popelka, Vice President of Legal and Governmental Affairs with the Kansas Livestock Association. Please introduce yourself and welcome to committee.
Thank you, Madam Chair, members of the committee. I'm Aaron Popelka, and I'm with the Kansas Livestock Association for, I think this is my first time here this year, so for those of you who don't know us, we represent about 5,700 members across the state, mostly involved in the beef industry, but also some dairy, swine interests, and diversified farms. We stand in support of this bill, and I think I want to maybe talk a little bit, Wendy, I think, hit some of the more technical highlights, but I want to talk a little more about what's really going on for landowners. I think in our testimony we have some data. Over 87% of the land is farm and ranch land across the state. And in these situations where there's eminent domain, this is not really a willing buyer and seller situation. It is where someone owns land that they potentially have held for generations, and another entity wants to force them to give it to them so that they can use it. And our state's been pretty clear that that's okay if there's a greater public good. And I think in some of the situations in particular, this bill is targeted at some of the electric utilities. We've seen some erosion a few decades ago where certain companies, well, you think of your electric companies that deliver power to your house. That is serving ratepayers. There's also another group of transmission lines that can gain public utility status and use eminent domain and not even serve Kansas ratepayers. There's a couple of these lines, and these are the lines that have really driven this conversation. These are for-profit companies that are simply exporting power. And I'm not saying exporting things is bad. Our members export things all the time. But when you're talking about taking someone's property so that they can use it to make money, you're in a whole nother ballgame. And all we're asking for, we're not asking for them to pay more than fair market value. We're just asking for some help in the process so that if there are errors, because again, this isn't a willing buyer and seller coming together, you have appraisers trying to guess using their professional judgment at the value, and errors happen, so that if there's an error and the court finds an error, then our landowners can avail themselves to the attorney's fees. Because a lot of times they face very large corporations that have lots of assets, can hire attorneys, and a lot of times we're talking about small farmers and ranchers who really may not have that ability. And like I said, it still says that you have to get an award above the appraisers. So it's just not because you decide to go to court that you get paid. It's only in that instance. So with that, Madam Chair, I'll pause, stand for questions at the appropriate time. Thank you.
Thank you. Do we have any other proponent conferees in the committee meeting room wishing to testify? Not seeing any, then I will note that we have proponent written-only testimony in your committee folder from Douglas Patterson, attorney, Patterson Law in Leawood, Kansas, and we'll open it up for questions. So yes, Senator Reichman.
Thank you very much, Madam Chair. I guess either one of the two proponents could answer this. Wendy's a little easier, Grady's easier to pronounce, so I guess I'll ask her. My question is fairly simple, but I don't know necessarily if you can answer, but you could go by past history. I was wondering when people challenge the eminent domain and how much is going to be money and so on and so forth, and they're asking for judgment and that type of thing. Can you give me an idea how much money that they could or they have received in the past? And then secondly, what does it cost for a lawyer for these farmers or anything to bring this forward? Thank you.
Please go ahead and reintroduce yourself. Thank you.
Thank you. Wendy Grady from Kansas Farm Bureau. I have one example that I was hoping to get the opportunity to share today of an existing or a transmission easement that is, or transmission line that is under construction or in the process of being developed. They are cutting through some farm ground, and this it's a specific case where there was also some other leases on the property that they are having to condemn. So it's a pretty profitable piece of farmland. From the initial offer that was offered from the transmission company through just the appraiser's award, there was a growth of 10 times in the amount that was originally offered to them. The transmission company is now appealing that decision. And just to get through the phase of the appraiser's award, it has cost our member almost $90,000 in attorney's fees. And that's even before they go to the appeal portion. So there's a lot at stake for landowners in this case. And I heard from other landowners too that maybe it wasn't the amount of money at stake, but the proximity of the line to their house that was concerning to them. And they said, look, I have a full-time job, my husband has a full-time job, we're raising kids, we don't have the time, money, or energy to address this. And so they ended up just signing the easement to have it go away. So if there are protections that we can give landowners to help them move forward and defend their position and get the right amount of compensation for these easements, I think that's a good step.
Thank you. Could you, while you're at the podium, could you just give a brief summary of what the condemnation process looks like for a landowner? What notice do they get in the mail? What kind of time frames are required by law, and what that would look like?
I should know more about this process than I do probably, but I think what you're getting out is the amount of notice for them. And to me, you know, the condemning authority has a lot of notice on this project. The projects have been in development for years before they go out and try and develop those easements or acquire the easements. And then it's 30 days or less, I assume, for landowners for the condemnation case. And it gives them a lot less time to prepare, and the utility companies, not only do they have the time to prepare, they're preparing financially too, because they know that there are going to be these costs in acquiring easements. And when you catch the landowners off guard with inadequate notice or the short notice, they don't have the financial preparation to help defend, you know, this acquisition of easement as well.
Thank you. The question kind of arises in the written proponent testimony. It's indicated that the property owner receives a letter from the taking authority, and generally 10 days to respond, and then if it's not a response that's agreed to, then a hearing is filed on the petition and with district court procedures, and you have 30 days to respond to the petition that's been filed in district court. So I think that's kind of the time frame we're looking at. If the revisor can correct me if I'm wrong on that.
Thank you, Madam Chair. You know, eminent domain typically goes to utilities, so it's not exactly my area of expertise, but I can get with our utilities revisor and double check that if you want. But I'm sure that the proponents and opponents are pretty familiar with that.
Thank you. Um, Do you see some of the suggestion in the proponent written testimony is to include an amendment in Senate Bill 61 that would give the landowner some more notice? This looks like 60 days before the condemnation petition is filed. The taking authority would need to give notice to the landowner, including a description other than just meets and bounds, and then 30 days before the condemnation petition is filed, the condemning authority would advise the property owner of an offer, and so negotiations would be occurring. Is that something, I guess, what are your thoughts on that?
Yes, I think we could be supportive of that. Any additional notice and additional transparency in the process would be good for landowners.
Is that something that Kansas Livestock Association has thoughts on, or? No. Okay, committee, other questions? Yes, Senator Haley, but first, I think Senator Titus wanted to kind of, okay, Senator Haley then.
Oh, thank you. Thank you, Madam Chair, and thank you for the testimony. So I guess my question is a little more elementary in terms of what the taking looks like. I mean, when I look at eminent, or when I'm hearing eminent domain, is it just the area where poles would be placed? Is there such a thing as airspace, or what are the areas that are encompassed in this appraised value? I mean, if there just periodically poles being placed that the appeal is for, again, it's probably it's a simple answer to it, but I'm just trying to get my mind around what we're talking about here.
So it would be the easement area underneath the transmission line and at a width that was sufficient to, encompass the sway of the line and what they would need for maintenance and repair of the line along the way too. So 150 feet or 100 feet in some cases wide, like the whole distance of the transmission line. And they would also have the ability to put in substations or buildings or other things that would support the line, and they would be able to acquire those, I believe, by eminent domain as well. So that is what it would encompass. And it's the right to use that land. So the farmers, ranchers, landowners would still have the right to use the land under the transmission line, but it can greatly impact their ability to do that, complicating it, especially like if they use guy wires that come down at a 45-degree angle. Those can be pretty dangerous for farmers and ranchers to maneuver equipment around and that sort of thing. So that would be the difference in just being able to use your land as you wish and now having to farm around and safety concerns associated with the lines too.
Thank you for that clarity. I guess too, Madam Chair, that would then allow the easement for maintenance by the company, the electric company too. So they'd have to provide or allow for, egress across the land as well for the maintenance purposes. Is that would be contemplated as well?
That would be. I can give an example from our personal property. We have a transmission line that goes across it, and we were able to reach a negotiated price on that, and the electric transmission company installed the gates to help them access the line too. So, yes.
Thank you. Brief follow-up, Madam Chair. It was more to, I guess, Mr. Popeka's assessment or testimony. So is this sometimes used for ancillary other than utilities? I'm thinking that they may use the poles. He referenced, Mr. Popelka did, that there may be for-profit entities that might also use, I'm thinking of telecommunications, for example. So if some poles are set up through this for, public utility, if those two could be used for a for-profit entity, say telecommunications, does that come into any discussion or any consideration during these appeals?
I'm not
ancillary.
sure if it comes into the appeals, but for-profit companies can have public utility status and the right to use eminent domain.
Oh, they do. Okay, I didn't realize. Thank you. Thank you, Madam Chair.
Thank you. I think Senator Titus is now ready with his question.
Thank you, Madam Chair. And I don't, this doesn't have to be for Ms. Grady if Mr. Popelka would like to answer, but is the gist of making this mandatory on the public utilities, doesn't that essentially shift that cost to utility ratepayers for the cost of the project? Is that, do I understand how that would probably play out?
It could, but only in the case that there was an inadequate level of compensation early in the process and the ultimate award on appeal is greater. So you could say that that is what rightfully the landowner should have been offered initially and a part of the cost of the line to begin with.
And why the focus on only electric utilities? What's the uniqueness of that? Why isn't the gas company up here and whatever else we'll have in the future and the telecoms and everyone else? Why aren't we requiring this provision to be automatic for everybody that provides a public service?
I think that's largely the result of what we've seen over the last year, 6 months to a year, on electric transmission around the state. There were major conversations around the NHTSA corridors, which of course are not going to happen in Kansas right now anymore, but also the Greenbelt Express and their AC collector lines out in southwest Kansas, and just the anticipated growth that we see in electric transmission around the state. This is the most imperative situation where we see eminent domain being an issue.
Thank you.
Thank you. Does Farm Bureau have any statistics about how many condemnation proceedings go to the appeal level? Do we know how many appeals are filed or what percentage of condemnation actions are appealed?
I do not have those statistics, and I would say it's a smaller number than it could be if landowners had assurances that they could help pay to get their just reward in the appeals process. So if they could have an attorney to help them get an adequate amount recovered, there could possibly be more.
Thank you. Senator Corson.
Thank you, Madam Chair. My question is really for whomever would like to answer. I want to just make sure I'm understanding what we're doing clearly. So it sounds like what we're doing is kind of taking a may to a shall with respect to the electric utilities companies, because if I look in section 1 on lines 15 and 16, it says that current law is that a court may allow as court costs an amount to be paid to the landowner's attorney as utility fees. So it sounds like currently judges do have the discretion and the ability to make these awards if they look at the facts and they think that such an award is justified. Am I correct in that understanding?
That is true. One other change there, though, is on who appeals. As it stands now, it's only if the condemning authority appeals that attorney's fees may be awarded. Our proposal would be to change that to either party appealing, the landowner or the condemning authority, and shall. Yes.
And I don't have a fix for you. I'm just listening to the testimony, but I always get a little bit nervous when we're sort of taking discretion out of the hands of judges to make those decisions based off the unique facts and circumstances to the case. And I sort of also want to echo that I do have a similar concern to what Senator Titus shared about how we're singling out electric utilities when we have many other kinds of entities that utilize eminent domain. And so that just does give me pause, but I want to listen to the rest of the testimony. So thank you. And thank you, Madam Chair.
Thank you. Senator Rose.
Thank you, Madam Chair. I have a question similar to your question. I appreciate your stories, but they're anecdotal in nature. So any data you could share with the committee would be helpful as far as how many landowners are impacted, and as the chair asked, how many appeals there are, and what the outcome of the appeals are as far as the difference in initial value compared to value after the appeal.
Okay. Yes, we don't have those numbers, but we can work to gather some. Thank you.
Thank you.
That would be helpful information to have. Thank you. Any other questions for our proponents? Yes, Senator Klemp.
Thank you, Madam Chair. And I will layer on to the other senators' comments. Having recently been through the pain of a eminent domain, I did find it was not a utility issue. It was more of a sewer issue. And it seems like there would be many more opportunities or eminent domain issues around property. If you include, I'm not sure excluding the rest of the groups would, it seems like we're missing something there, but it's, I just wanted to layer on to those comments, and I look forward to learning more.
Thank you. Senator Bowers.
Thank you, Madam Chair, and hello, Wendy. It's good to see you again. I don't have a question, just a comment for the committee to know the effort that Farm Bureau made over the summer on the Department of Energy's proposal to it was called NITSE, and there was so much confusion over this topic of what the grain belt line that was already going through, KCC hearings on feeder lines, so much confusion on this topic. So Farm Bureau came around to North Central, Western Kansas and held informational meetings for the public to come to so we could understand and sort out the facts. And Farm Bureau did, and Wendy in particular, did an excellent job with the slideshow and what Farm Bureau's policies were at that too, but just tried to sort the facts from the fiction of what rural legislators were going through in this 14-county area. And I just wanted the committee to know how much effort you put into tell the facts and not one side or the other, but so that we were informed properly with so much misinformation that was out there. It was a perfect storm of confusion. I can't say that any better, and thanks for helping us sort that out, Wendy.
I appreciate that. Thank you.
Thank you. I'm not seeing any more questions, so Senator Shane. As soon as I say that, then a hand raises. But
Came to me. Thank you, Madam Chair. Ms. Grady, just one question. Have your members found that there's any long-term impacts on property values by having easements that run through their properties?
I don't think, I don't have the information on that, except that some areas where there are multiple paralleling lines, I think those clearly have had an impact on property values.
Thank you.
now the easements weren't a taking of title to the land. It was just an easement for the purpose of a siting for a utility pole. Is that kind of what we're looking at?
Correct.
In some of these instances. And for the award, as the bill proposes for the landowner's attorney fees, then it would be an award like for the condemning authority at the appeal process. So if the settlement negotiations don't provide an agreement between the two, and then the petition is filed, and if the award is accepted, then there wouldn't be any award of attorney's fees to either party, correct?
That is correct. It's only after that appraiser's phase where there would be an appeal that the attorney's fees would kick in.
So for both of the parties, whether it's the plaintiff condemner or the landowner, if one or the other is appealing, something has sort of broken down in the process? Is that what you would say, or?
I would say yes, but I mean, could be tactics where condemning authority would appeal just to kind of exhaust the resources of a landowner. I think this provision would help prevent that kind of case from happening too. Not that that is happening, but that's something that could be prevented, I think, by this amendment.
Well, that kind of goes to my question as well as another senator's question about the data. How many cases are appealed? You know, because you're far down the road at that point, I would think, because you've had discussions and then you've had the lawsuit and then one has decided to appeal. So I'd be curious to see what kind of percentage of cases we're talking about.
And I think that could greatly vary if we pass this amendment, when it would be more doable from a landowner standpoint to go to that appeals process and not accept whatever appraised award was given.
Thank you. Senator Titus.
Thank you, Madam Chair. Sorry, Ms. Grady, I'm a little cold medicine fog brain this morning, so I'm still warming up. But when I look at 26509, it reminds me, having practiced in this area some for the state, the original intent was to stop, the way that's structured initially is to stop the government from bullying a landowner with a needless appeal for a small amount. And right, if they don't have the money, they get drug into court for something, they just want to take the offer and be done, right? I think that's was the original intent. So it's to discourage the state from being too aggressive because it would cost them more to maybe get a slightly lower valuation if they wanted to take the risk. But it looks like you've flipped the incentive with new subsection B, and this actually encourages landowners to continue the litigation process further. I'm not going to ask you to agree or disagree with that characterization, but am I working through this correctly?
The only encouragement it gives them is some assurance that if they do get the award on appeal that they think is fair and just, that they think the appraiser's award was less than necessary or less than what they deserve, then they would get their attorney's fees. So they will not be taking on frivolous appeals just because this amendment passes.
Thank you.
Thank you. We do have a question from Senator Clays.
Thank you, Madam Chair. And thank you for coming today. My question is just, while you're out there gathering data for my colleagues, I was wondering if you can also find out what perhaps the average attorney fee is for a situation like that, so we know what numbers we're talking about, and if maybe that could be maybe capped if it got too extreme, just so everybody knows what we're talking about.
Okay, we'll work to gather that too. Thank you.
I'm going to also ask our research analyst who's here, is it possible to determine across the state, across the 105 counties, how many condemnation actions are appealed? Is that something that you could do a search for and determine? Or, I don't want to be making a request that's practically, for logistics and as a practical matter, not possible.
Right. This is Natalie Nelson from Legislative Research. My first instinct would be to contact the Office of Judicial Administration. They do keep a lot of data on various types of cases, so I can reach out to them and see, but I don't know for sure.
That would be helpful as well. So with that, are there further questions for our proponents? Yes, Senator Schmidt.
Does the Corporation Commission have any role in this process for the utilities that you're discussing?
Not necessarily. Their role is the line siting process, which once a utility goes through that, then that's what gives them that eminent domain authority. But they don't have much of a role in the actual acquisition of easements or eminent domain once if agreement can't be met. So.
Is it possible that there is an initial process that they could add that would give any way that they gain authority to do this?
I'm not sure. I haven't reviewed the statutes. I don't think the authority exists for them now, but I know that at least with some current line siting cases, they were pretty instrumental in helping conversations between landowners and the condemning authority, at least on an informal basis, to help, with micro-siting matters and other things that would make it more workable for both parties. No, that is just an electric transmission example that I have, and that's where my knowledge is. Thank you.
We do have opponent conferees wishing to testify, so with that, we're going to thank you for your testimony and appearing today and answering questions as well. We do have opponent conferee testimony from Dave Peck, Director of Project Management, on behalf of Evergy, ITC, Kansas Municipal Utilities, Liberty Utilities, and Nextera Energy Transmission. Please introduce yourself and welcome to committee.
Thank you, Madam Chair and members of the committee. My name is Dave Peck. I'm the Director of Project Management for Evergy. I work in the Transmission and Substation Construction Group for Evergy, and today I'm here before you representing not only Evergy, but ITC, Kansas Municipal Utilities, Liberty Utilities, and NextEra Transmission. So thank you for the opportunity to come here and speak about this. I've worked in the power industry for 30 years. I've worked at Evergy for 16 of those years, and I've done a lot of transmission projects all across Kansas. My job is to either rebuild existing transmission lines or build new ones, and also some substations. In almost every instance of these projects that I work on, it requires some type of a real estate transaction, mostly for a transmission line in the form of an easement. So we get an easement to put our transmission lines on a piece of property. The property owner doesn't change. We just have rights to put the transmission line on in the conductors. So as a utility, our approach to easement acquisition and related to eminent domain is to only use that when it's absolutely the last resort. We don't like condemning people. It doesn't look good for our company. It looks like we've got a big utility that's picking on a small landowner. So we try everything we can to try to get a negotiated agreement. One of the concerns that we have about the proposed bill is it does, in our opinion, give the landowner more of an incentive to keep appealing. So we try to balance risk and reward. And in this case, we're removing the risk from the landowner, and it's only a reward if the appeal goes in their favor. So like I said, we try to negotiate negotiated settlements. We try really hard to avoid condemnation. In some cases, it's not an issue of one party not agreeing with the other. It's more of a title problem. So an example that I'll give you is a project that I worked on in Manhattan. We're trying to get an easement on a piece of property. We go and we do title work, and we figure out that the property owner is deceased and it didn't go through a probate system. And so in those cases, we can't get an easement from a landowner that's deceased. So we have to file a eminent domain, and it goes to the court, and then the court and the landowner work to go through the probate process. They hold the money, and then when they're done, they get paid. So those cases happen quite a bit, actually, and it's another thing to consider. So the issue of condemnation has been a hot topic. We feel it when we're out there trying to acquire easements. And it's like I said, it's one of those things that we really try to avoid. Our company, it takes a officer level to get approval to proceed with eminent domain. It's like I said, it's not something that we take lightly. One of the things that we noticed in the bill is, again, we've heard your questions here. It does seem to target just electric utilities, and there's a lot of other utilities out there that use eminent domain, along with KDOT and some other utilities or entities like that. The Kansas Corporation Commission is talking to the utilities about adding some language in their siting process. So for certain transmission lines, we do have to get a siting permit from KCC, and they want us to add some guiding documents in that when we file for the permit, and we're glad to do that. And it mostly doesn't require us, the language that I understand it today wouldn't require us to change anything, but we want to be more transparent and make sure that everybody understands kind of how this process works. So I'm going to change hats real quick, and I'll talk to you about some of my personal experiences with just on the Evergy side. So I've got firsthand knowledge that I'd like to share with you guys. And again, I think that the other industry, electric utilities, probably follow these same rules, but I don't want to speak in their behalf. I'm just going to speak to you right now from an Evergy perspective. So as someone that gets involved in this work and has to go out there and execute it, I can tell you wholeheartedly. Trying to get a siding electric transmission line on a piece of property is the hardest thing that we do. We understand what we're asking people to do. There's nothing in a farm field or a pasture right now, and we're going to put a power line through there. So it's hard for people. It's hard for us to go out and ask people to do that. But we have a job to do, and it's to put critical infrastructure in place. And these projects are needed to help support our electric utility. And I haven't met very many people that don't use power. Everybody likes their electricity, and everybody wants it on all the time. So that's what we're out there to do. One of the things that we do to go through the process is we try to be as transparent as we can. When we engage with a routing study, there might be a big area that we're trying to get from point A to point B, right? We've got to deliver power from one end to the other. So we try to throw many routes in that area, and then we work with the community to figure out which is the best route. And then we settle on a route, and then we explain to the people, hey, this is the process that we went to, and now we're here to work with you to try to get this easement in place. So we also want to recognize our goal going into these projects at Evergy is to try to get 90% of the easements through a normal negotiation process. And if we see that we're getting out of bounds, we'll stop and we'll try to adjust and do some things that maybe we can help that along a little bit. In some cases, we don't have any problems, and we get 100% of them through a normal process. There are, however, some cases where we can't do that. And again, when we engage the landowner from the beginning, we try to be transparent and let them know this is the process. So we explain the whole process, and then we also have a schedule that we have to follow. We don't have unlimited time to get this infrastructure in place. And so we will tell them, here is the deadline when we are targeting to exercise our rights for eminent domain. And this is months in advance. So we try to get everybody informed and not surprise anybody. We don't want to show up and everyone's like, hey, why did you do that? You know, we don't want to do that. We want to bring them along the whole way. We send out a letter to the landowner letting them know that, hey, we're at the 30-day mark, and we're going to try to work hard with you and get a negotiated easement in the next 30 days, but here's the deadline when we're going to hand it over to our legal team. So once that handoff occurs at Evergy, then there's another, now the legal team is engaged, and then there's another notice letter that comes to the landowner to let them know, hey, you're not dealing with Dave's team anymore, you're dealing with the legal team, and it kind of goes out of our hands. We support them, right, but it's kind of started, that process has started. So I also want to recognize that the majority of people that we work with do, through this process of being transparent and getting an understanding of why this is needed and why it's critical infrastructure, that the majority of the Kansans do work with us. And I want to recognize that and thank them for that, because it's not easy to do, to give up a right that you have on your piece of property to help the good of the public. But a lot of people do, the majority of them do. So that's the end of my spiel. So thank you for your time. On behalf of the electric utilities, we just would urge you not to take any action and just leave the process as it is today. It works really well for us, and I'll be happy to answer questions at any time.
Thank you. Committee, want to also note we have opponent written-only testimony in your folders at your desk from Reagan McLeod, Director of Government Relations, Kansas Electric Cooperatives, Inc. Do we have any other opponent conferees in the committee meeting room wishing to testify? Not seeing any, then we'll open it up for questions for our conferee. Are there any questions? Yes, Senator Shane.
Thank you, Madam Chair. And thank you, Mr. Peck, for coming and speaking with us today. The first would just be a data request, which you might have on hand, or your members might have on hand. I think that just helps us better understand where Kansas sits today, and some of that relates to the changes and the projections as far as, you know, how many acres or miles are we talking about as far as, moving into the future and potentially having either a map or the data presented where we understand, how many miles of lines were we talking about 25 years ago, 10 to 25 years ago, in the last 10 years, and what's projected for the next 10. I think it just helps us better characterize our current status in Kansas. I think you guys would be best equipped to do that, as well as share with us, thank you for sharing the 90% kind of KPI target that you guys have, but it might also be nice to understand how many negotiations do you all enter into, and again, just help understand how many Kansans are you working with to work through this challenging issue. So really just data requests, not so much questions for you at this time.
Sure, yeah. I should have, before I came, I should have had, like in my bio, right, that the company sends out, that I calculate how many miles of transmission lines, and I don't have that number, but in my recollection, it's maybe in the 400 or 500 miles of transmission lines in Kansas. And just to give you an idea, only in 2 cases, 2 times, have I been involved in appeal. So that's from an Evergy perspective. So we'll get you that information though, yeah.
Thank you very much.
You said you've been involved in 2 appeals. Does that mean the greater percentage of your transactions with landowners resolve in a settlement without having to file the condemnation petition? Is that your experience?
And a condemnation appeal.
Okay, and what about the petition being filed in the first place?
Like I said, our goal is 90% through regular
settlement before the
10%. And again, it varies per project, but one just recently, we had a U-Haul moment because we didn't have any condemnations, and that happens a lot.
So 90% you said is kind of your target.
Yes.
Without a petition even having to be filed?
Yes.
And in how many of the cases where the appeals are taken are attorney's fees awarded? Is it unusual for the court to award attorney's fees at all? Because the court does currently have discretion to do that for the condemner.
Yeah. The only thing that I can tell you about is the 2 cases that I was involved in, and the judge did award fees to the or the winner's fees were paid by the loser, if that makes sense. You can tell I'm not a legal scholar, right? So.
I think currently, rather than the prevailing party can be awarded attorney's fees, I think the court may allow attorney's fees to the landowner's attorney only. Am I reading that correctly? So go ahead, Ms. Scott.
Thank you, Madam Chair. Yes, so the attorney fees can only be paid to the landowner, and that instance has to be when the plaintiff condemner is the one making the appeal. So those are the 2 restrictions.
Right. In this case, the electric company is making the appeal and the landowner prevails, then the court may award landowner attorney's fees currently in our current statutes. Thank you. Committee, are there other questions? Senator Rose.
Thank you, Madam Chair, and thank you, Mr. Peck, for being here with us this morning. Why can't you just use land that you already have an easement on? Why do you have to continually use eminent domain to make new land? And also along those lines, is there a master plan that Evergy has for the next 100 years where once we have this land secure, then future transmission projects will run on the land we already have secured?
You know, we don't have easements on every piece of property. That's the reason why if we do have a transmission line and we're rebuilding, we will use our existing easements. In some cases, maybe we have to increase the voltage, which might mean we need a wider right of way. So we would just acquire strips on the side. So that happens sometimes. So that's the reason we don't, on a greenfield project, there's just no easement there. Your other question is really complex, so I'll do my best. The transmission, I'm going to call it the grid, right? It's all connected. So imagine that we took every generator offline in the United States and we fired up a generator in New York. Our lights, you know, and you turn a light bulb on, it would light. So it's really hard to, for every utilities involved in that. We've got lines that connect to other utilities and things like that. But the Southwest Power Pool is the one that is kind of the air traffic controller. And they're looking at power needs and where our pinch points are. And it's a really dynamic situation right now because we've got some coal-fired plants that are being retired, and now you have to replace that with new generation, and it's not in the same location. So you were generating power here and pushing it that way. Well, now you're over here and you're pushing it that way. So again, it's a really dynamic situation. But most of the new transmission that we build is because they've studied it at the power pool level, the greater level across the multi-state area, and they see a need that we have to be at power from point A to point B because we're about ready to burn up some lines. They're carrying too much power. So there's a whole process for that. They're looking out like 10 years. And
Thank you, Madam Chair.
Maybe you don't have an answer for this right now, but currently the court may allow attorney's fees if the plaintiff condemner appeals and the verdict for the landowner is greater than the appraiser's award. Would there be better comfort for the opponents if the proposed change, instead of shall allow, would also be a may in the instance that the landowner appeals?
I guess I can't speak for that.
And if you can't answer that right now, it's just kind of a, to some other comments, you know, may allows the court discretion, and the bill proposes shall, so maybe the may would help provide some comfort on both sides. I'm not sure, so.
We can take that back and study it.
Thank you. Are there any further questions? Oh, yes, Senator Bowers. I'm sorry, Senator Bowser. Sorry.
It's going to take a little while for everybody to get used to that. Thank you, Madam Chair. And I don't really have a question, but just want to share kind of my personal experience, maybe some comments here. I own a farm. I have a utility line runs through it. I agree to my appraised property value every year when I pay my property taxes. And I believe that the utility companies operate in good faith. They try to be pretty honest and fair and above board. I think, and my understanding is, and I could be wrong, but somebody mentioned the Grain Belt Express. That's a very large transmission line going through our state. My understanding is that about 98 or 99% of the landowners have already agreed to a settlement with the utility company. So I think what we're talking about here is very, again, numbers would help. We've heard several senators mention we'd like some statistics and some numbers. But I think we're probably talking about a very few, small number of folks who can't come to an agreement, who make an appeal. And so I think we're really talking about really a small number of folks here. Thank you for your testimony today. Thanks everyone for your testimony.
I think that's the testimony today too, that 90% is kind of the goal of reaching settlements, and it does on behalf of the utilities. Most of them are resolved short of filing the condemnation petition due to the conversations and the notices that the utility companies provide.
And one thing I can share too is after the legal team gets engaged, oftentimes we do reach an agreement once that happens. So we continue to negotiate through that whole condemnation process. It's not that we say, don't talk to us anymore. We always try to work things out. And sometimes that does help. And actually, you don't go to the courthouse for every condemnation.
Thank you. I'm not seeing any more questions, so thank you for your testimony and answering questions. Are there any neutral conferees in the committee meeting room wishing to testify? I'm not seeing any. So with that, then, we will close the hearing on Senate Bill 61. We have one more item of business regarding the meeting minutes from January 21st, January 22nd, and January 23rd of 2025 submitted at your desk there. And do we have any discussion, or I'll entertain a motion on those minutes? Senator Haley. Thank you. Is there a second? Second from Senator Shane. Thank you. You all have heard the motion. All those in favor signify by saying aye. Aye. Those opposed, no. The motion carries. With that, then, remember, we are not meeting tomorrow, and Monday is your last opportunity in our committee meeting to introduce or at least make requests for bill introductions. With that, have a great weekend, and we are adjourned.